Good evening. Every Tuesday, we do bring in immigration live updates. Along with me is business partner Emily Neumann. Emily, what do you have today?
Yeah, we keep hearing more and more reports of people who are attempting to get their H-1B or H-4 visa stamp at the consulate and now being rescheduled for their interview into May 2027, over a year from now. Why is this happening? What's the problem? What can be done about it? And we have various travel bans, visa bans, 75 countries, 19 countries, 30 countries. Really hard to keep track of all of that. So we'll kind of talk about the common questions we're getting on that and how it's impacting applications that are filed with USCIS as well. And then Prudential visa revocation. So we know that the Department of State has gone through, and anyone that had any kind of law enforcement interaction, even if it was before they got their most recent visa stamp and they've already been vetted at the consulate, they're going back and prudentially revoking their visas, or even doing it for dependents when it's the main H-1B holder who has the law enforcement interaction. What's happening with that and what you should need to know. And then today we have a story out of Texas where the governor has decided that Texas universities can no longer sponsor H-1B visas for their employees. They cannot file extensions for anyone, and that ban is in place until May 2027. They have to get special permission from the Texas Workforce Commission. Right now it applies to Texas universities and state agencies, but could that spill over into the private sector to where Texas just bans all H-1Bs? We'll talk about that as well.
First, I just want to tell you that there is definitely an anti-immigration sentiment going all around. We have seen a lot of YouTubers also striking against the H-1Bs. This is a time where you need to be very alert on what's going on. At the same time, not go into the fear mongers that they're arresting everybody, they're deporting everybody, even if you don't have any papers. No, we have not seen any of that happening where people are getting arrested. So please be watchful about those news though. And we come to the point of the visa, the no visas appointments available. When you check online, though, when you want to try to make an appointment, there are no visa appointments available, particularly for the H-1B visas and for H-4 visas right now until 2027. Is there any official announcement on it?
No, they are not acknowledging it in any way. This, I think, still stems from their plan of social media vetting, where they went back and canceled visa interview appointments saying we need fewer slots available because it takes us more time to do this social media vetting. But they're continuing to not open up the slots. And this is something we saw during the previous Trump administration. It is a relatively easy way for them to keep immigrants out of the US. Once you're out, they don't have to give you a visa appointment for you to come back. I think that's their goal is to get as many people out as they can. And then they can limit who can come back into the US. So it's falling right in line with everything we've expected of the Trump administration. So I'm not surprised it's happening, but it is certainly problematic for people who had appointments and traveled or need to travel but don't have a visa stamp. I mean, there are valid reasons for travel. It's impacting business travel. If someone needs to go for a meeting and they can't get an appointment, then they are either choosing to be stuck outside the US or miss the meeting. And so it's impacting business as well.
Definitely at this point of time, as always, we have advised people from the time Trump administration is do not travel outside the country. Even if you have an appointment, do not travel outside the country. Even if you already have the visa stamping, do not travel outside the country. And please do not travel right now outside the country, because while you are in USA, there are many provisions available, but once you leave the country, there are not. Even if your company is willing to let you work remotely for a while, though, still do not travel outside the country. Even if you have the passport stamping, do not travel outside the country. So this is applicable to all non-immigrant visa holders. Now, when it comes to the advanced parole holders, so definitely if you have any arrest records, do not travel outside the country. But in general, we are not seeing any problem with the people who have an advance parole, any problem in coming back into the country. We definitely recommend these people Not to travel for extended period of time, but a short period of time is not a problem. For those people who are green card holders also, we get a lot of calls, panic calls. Hey, you're telling me not to travel. Can I, even the green card holders, now for the green card holders, definitely if there is any arrest record, we want you to check with an immigration lawyer before you travel. But 99% of them are clean, not a problem. So for those people who are clean, you can travel as long as your travel is limited for less than 180 days. We don't have a problem. If it's going to cross more than 180 days, we want you to check with an immigration lawyer. Not only that, if you ever had any travel where you were outside the country for more than 180 days, do not travel. Check with an immigration lawyer before you travel. Anything else, Edwin?
No, I think we can move on to the 75 country ban. Where do we stand with that? How is it impacting cases with USCIS?
We are noticing RFEs, Emily, where I've seen RFEs where people have filed for I-539, say that they filed the change of status to B2, they filed the change of status to they changed the change of status to H4. We started receiving that, hey, your country is banned right now. We may not be able to adjudicate your application. So they're issuing an RFE on it. We have started noticing it. So for most of the countries, though, you can file the change of status, but the USCIS may not or probably will not approve the change of status. And if you are filing an H-1B extension, they may not approve the H-1B extension. What's the story on H-1B? If my H-1B is expiring, Emily, in let's say in September of 2026, can I file a H-1B extension if I'm in this list of countries and get it?
You can file it. There's no guarantee that you're going to get it, but the good thing about filing it is it provides you with an automatic 240-day extension of your ability to work and remain lawfully in the country beyond your current I-94 end date. So it's not 240 days from when you file. So if you're expiring in September, it's 240 days beyond September. That's for an H-1B extension. However, if you file an H-1B amendment plus extension, then that's treated as H-1B portability that allows you to keep working the entire time the extension application is pending. So if they're just going to hold the application and not adjudicate it, well, you can keep working and stay in the country the entire time it's pending in that situation. The other situation that comes up is
Hold on,
EADs.
hold
Yeah,
on,
go ahead.
hold on. So H-1B extension, you know that you can only work for 240 days. You're telling me that if an amendment plus extension has been filed, there is no 240-day rule, and especially if these people who are belonging to the 75 countries, though, as you know that let's say the I-94 expires in February of 2026. Now, if I file the extension, now they get only 240 days because the USCIS is not going to approve the application. So they can only work for 240 days. But if it's an amendment plus extension, and I file the extension, amendment plus extension from February of 2026 all the way to February of 2029, are you telling me if they don't adjudicate, I can continue working until February in 2029?
Yeah, I think so.
Okay. That's a very clever hack, Emily. Um,
Yeah, and the same is true for H-1B transfers. If you're wanting to change companies and your new employer files a 3-year H-1B transfer, you can work for that new employer for 3 years, assuming they just don't adjudicate the application.
you're speaking something on EAD assembly?
Yes, EADs are a bit more troubling because we're seeing the same issue come up, especially for STEM extensions of OPT. And that's where the automatic extension does still exist. There's a 180-day automatic extension of your OPT while you have your STEM extension pending. Unfortunately, it's only 180 days. So if you file your STEM extension while it's pending because they're holding it because of this travel ban, your current OPT expires. You can keep working for the next 6 months, but after that, you have to stop working. You can stay lawfully in the country. You're still considered to be in F1 status, but you no longer have work authorization. So that's one problem. And then the other problem is for people, with a pending 485 that are filing their EAD renewal. Now there's no automatic EAD extension for these GC EADs or the C9 EAD. And so you can file that EAD application, but once your current EAD expires, if the new one's not approved, you're not going to be able to work if you're using that EAD. So those are a bit more problematic.
For those people who belong to these 75 countries, so we strongly recommend that you consult an immigration lawyer, have a plan of action, what you're going to do if your thing is not extended. Is there a plan B? Because those things. Emily, does premium processing work in these cases, though?
No, it doesn't. They'll take your money and then they'll just hold the case and not approve it within the 3-week premium processing time. Then you have to struggle with them to get a refund of your premium processing fee.
For those people whose visas have been prudentially revoked for any of the arrest records, even if it's a traffic violation where people have forgot to pay the money and then they got an arrest warrant and their visas been revoked, for those people, there is a new a development that's going on now. So in this particular case, the husband, H-1B got revoked, and the wife, who was in India, was going for H4 stamping. However, when she went for the H4 stamping, they told the husband has to come here to get the H-1B stamping before you are allowed to go on a H-4. That's kind of new interpretation, but technically speaking, about if the husband is working illegally in the United States on H-1B and is working for a company, they should have been giving the H-4 visas, but now they're telling they're not going to give the H-4 visas because this gentleman's H-1B has been revoked, and and they want this gentleman to go outside the country and get the stamping so that she can get the H4 stamping. I'm right now, if the people go outside the country, this guy, they're not giving the H1B visa for him either.
Mm-mm.
So you have to take a decision if you want to pack your bags and leave or stay separately, or we'll look into the litigation options. Stephen Brown can answer those questions on that, whether why they should reject H4 because the husband is already here in H1B. So that's something that you may want to look into. But otherwise, we don't recommend the husband to go outside the country and get the try to get the H-1B stamping.
Yeah, and the other thing with that, this is called a prudential visa revocation, meaning that it doesn't take effect until the husband leaves the country. So while he's in the US, his visa is not revoked. So how can they claim that they're going to deny the H4 because the husband's visa is revoked when it's not technically revoked until he leaves the US? There's no requirement for him to have a valid visa when he's physically in the US maintaining H1 status. So hopefully we can get that reversed, whether that's through litigation or reaching out to the consulates. Hopefully it's not a new trend that we're seeing, but definitely, again, reiterating that travel is not a good idea, regardless how safe you feel it is, how many times you've gotten stamping before, whether you have a valid visa or not. Just don't do it right now.
Florida governor started the assembly where he said no more H-1Bs for the universities, though. Now we got the Texas governor that issued a notification that they are not going to have any new H-1Bs filed, no H-1B extensions will be filed, no H-1B amendments will be filed, no H-1B transfer will be filed for the state universities, not only state universities, but also state agencies, especially the I'm a bit concerned about the healthcare agency where we see a lot of doctors on H-1Bs, a lot of nurses on H-1Bs. Can you elaborate on that? What's going to happen? What's happening?
Yeah, so the governor for some reason feels that we must have plenty of Americans available for these jobs. And so they want Americans to be the ones to be researchers at these top tier universities, to be the professors, to be the doctors. Because we don't have a shortage of any of those. Being sarcastic, of course. But because they feel Americans first, whether they've ever tried to actually fill all of these roles that are open with Americans is a different story. They think that we shouldn't be allowing universities, state-owned universities in Texas to apply for any new H-1Bs. So if you are currently on an H-1B, working for one of these universities, you won't be able to extend it, unfortunately. Your current status remains valid, but the next time you need to file something, they will not allow that to be filed. The universities are not going to be filing anything going forward. If they do want to file an H-1B, they have to get special permission from the Texas Workforce Commission. And this ban goes until May 2027. So we have a year and a half to get through that. So if your H-1B is expiring in the next year and a half, you're working at one of these schools, you may need to look outside of Texas in order to continue your status.
And most of these people, Emily, are exempt, some of them, especially from the medical residents and certain other people, they're exempt from the uh, H-1B cap. They can't just go and join some other organization. What about the school districts, Emily? Is the school district affected? Because a lot of teachers are on H-1B. Are they affected by this Texas governor and also the Florida governor, Emily?
It does not appear that Texas school districts are impacted by it. They're not considered to be state agencies. So private universities, private employers, cities, counties, school districts, local governments should not be impacted by this. It's the actual state agency. It could impact hospitals, particularly the teaching hospitals are likely to be impacted, but the universities also. But thankfully, the governor does not have the authority to restrict private companies from sponsoring and using H-1B visas. So limited in what authority he has there, but it's definitely a blow to those universities who are trying to attract the best and the brightest to teach our US kids. I mean, don't we want the best researchers? Don't we want the best professors here to maintain the top tier status of our schools in Texas? We're just shooting ourselves in the foot with that.
And especially, I don't know why these politicians don't observe that most of the doctorate students, at least 80% of the doctorate students in research fields, Emily, are foreigners, though. They are not local people, though. So that definitely is going to lose the edge for the Texas state universities. Now, that doesn't apply to the good Rice University kind of university that we have, but it does apply to the state universities that they're speaking about.
Yeah, I mean,
And
I was a former PhD researcher before I went to law school. I can tell you that not one person that I went to high school with went into research, got a PhD. I never finished my PhD, but I did start. um, and that's just not something American kids are going into. There are some, but it's not like there's just all of these American PhDs waiting in the wings that don't have jobs that are going to come and fill these positions. I don't know what they're thinking. Where are these professors going to just miraculously appear out of nowhere?
let's go to the question. Subra from Facebook is asking this question to me. Is it true that in Abu Dhabi airport, a person was been deported for being an H-1B working from India? Absolutely not. Now, I know some people in the past 1 week who have been sent back from Abu Dhabi. Some of them definitely have some very bad criminal records. So they won't come and tell you about this, that they got deported because they have the criminal record. Will they come to you and tell that, oh, I had some marijuana issue and then they caught me there, and because I was involved in marijuana, they deported? They won't tell you that. So they tell this lame excuse saying that, oh, I was H-1B, I was working in India, and then I got deported. First of all, if you are in India, the US government doesn't care whom you're working, because you will come under the jurisdiction of the Indian government. I am assuming that whatever you are speaking about, that person is an Indian. If that person is an Indian, and is working in India, well, I'm a lawyer in India, and I don't think so. This requires a lot of legal skills to answer this question. Is that, can an Indian work in India? The answer is simply yes, they can. I have a license. I'm a licensed lawyer in India, happens to be. But Come on, that's an easy question. An Indian citizen can work in India. For the Indian citizen to work in USA, of course, you need H-1B, OPT, STEM extension, L1, O1, P1, Q1, all those things, and probably the immigration lawyers like Emily and me, or some other person like that. But for Indian guy, Indian citizen to work in India, you don't need any work permit in India to work in if you're an Indian citizen.
All right. Vinay says, how does the Prudential H-1B revocation get communicated? It is typically just an email from the Department of State or from the consulate. It almost looks like it's spam, so some people miss it. And sometimes it's not communicated at all. Like if you got your visa years ago using a different email address, you might completely miss it. So you can go to the SEAC website where you completed your visa application and try to look up your visa status there to see if it is showing revoked or not. That's really the only other way to find out if you missed the email.
Tejish Malay has this question. I got a revocation mail today on my H-1B, but I don't have a H-1B visa at all. I don't have H-1B stamping. I only have the F-1 stamping, which is expiring, but they say it's a H-1B has been revoked. So I'm a bit wondering, is it a F1 that got revoked or H1 that got revoked, which is wondering. But let me tell, though, if ever anybody has any arrest, though, or any warrant that has been issued, though, you have to assume that your visa is already revoked and you cannot travel outside the country. Simple, that question is there. At the same time, we want you to be careful on some of these fraudsters that are sending emails saying that your visa has been revoked and you come to this particular site or you call this number, you pay me the money. No, the US government has never asked any money either after they revoke, or if they are going to revoke, they're not going to send a notification, pay me the money, otherwise I'm going to revoke it. These are all fraudulent agencies. We have seen some of them cashing at this point of time. We want you to be very careful with that. The US government does not ask money for you. So if they're asking money, then it's probably fraud. It's 99.99999% fraud, or probably take it 100% fraud. If they're telling you that you cannot speak with a lawyer in between, they are fraud. If they're asking you money, they're fraud.
It says, is the ban on the 75 countries applicable for family-based immigration, or does it include employment-based also? It does include employment-based also. The reason people talk mostly about family-based are kind of two reasons. Number one, when you're talking about immigrant visas issued at the consulate, not adjustment of status in the US, it's mostly family-based immigrants that go through the consular processing. Most of employment-based tends to be adjustment of status. So you hear more of it impacting family-based cases. The other reason is we know that if there are unused family-based green cards this year, because of this travel ban, they spill over to employment-based last year. So people kind of focus more on the family-based side of it, but it does include both.
Will there be spillover from family-based to employment-based due to 75 countries? We are expecting. We're expecting between 40 to 60,000 green cards to be spilled over because of the 75 country ban. That is our expectation. So there may be some movement in October of 2026 for the employment base, though.
Sid says, what changes are expected in the EB1 and EB2 NIW rules or criteria? And will it impact pending petitions as well? So there is planned to be a proposed regulation for immigrant petitions, I-140s. Nobody knows what's in it. It does seem to be that they are going to be revising some criteria for EB1, EB2, as well as PERM-based I-140s, looking at bona fide employer-employee relationship and those sorts of things. The proposed regulation has not been published yet, so we don't know what's in it. We don't know what they have planned. I can only expect that it's going to make it harder, not easier.
Questions on the Prudential visa revocation. Are we expecting any deportation, ICE getting arrested, Or if I travel domestic travel, will there be any problem at the airport? This question is coming from Subu4855 from YouTube. Absolutely not a problem. Nobody will be arrested if it's a just a prudential revocation. If the crime is like, for example, DUI or something, definitely not a problem. But if it's a drug offense, for example, definitely there are some problems with it. You might, if you have already have a criminal charge, you must have already spoken with the immigration lawyer, and the immigration lawyer said, no, you will not have any problem. Then you will not have any problem. You will not have any problem in traveling domestically. ICE will not come and arrest and deport you. Absolutely, that's not happening. That will not happen.
Hardik says, I'm overseas with an expired H-1B. I have 3.6 years of recapture time left. Will the $100,000 fee apply to my new employer if I try to come to the US on H-1B? Yes, it will, because your new employer has to file for consular processing because you're outside the US and you don't have a valid visa stamp. They will need to pay that before filing the H-1B.
Texas freezes H-1B hiring. What does it mean for nonprofit hiring? This is not about nonprofit. This is only government agencies. There may be some government agencies, like for example, University of Houston may come under that particular thing, but it's not all nonprofit organizations. It's only the state-owned organizations, state-funded organizations, and state-owned organizations. Not exactly state-funded, but state-controlled organizations.
Pre-X7E says, are you seeing approvals for AOS applications from people in the 75 country list? No, we are not. We have people on that list with pending 485s, interviews already done, cases ready to be approved. They're just sitting on it. No approvals.
Does the visa which has been revoked get reinstated when the criminal charges get dismissed? Absolutely not. Let me tell you that most of the people's visa who's been revoked, their cases got dismissed. And so don't be under the assumption that since your case gets dismissed, the visa revocation will be taken back. No, you're under the wrong presumption. One of the guy, his name is User, he's a doctor, he's an EB1 approved applicant, and his wife is stuck in India with H4. He has a 2-year-old US citizen kid, and his priority date is current, and he is contemplating on, he's saying that I'm not going to file the adjustment of status without my wife, though. I probably would recommend that you contact an immigration lawyer, because I don't know how long your wife is going to be there in India. Is it worth probably to convert your application into a consular processing and get everything done in India? You may want to consider that. You may want to also consider to see if you just want to file the 485 application, get the green card by yourself. But of course, if your wife is completely dependent, like an H4 person though, then she'll be stuck outside, because once you get the green card, she can't come here on a H4 visa. So a lot of things you may want to get evaluated by an immigration lawyer. I'm not telling that what you have right now decision is wrong, but at least go over all the options and then take a decision.
Respect my authority. I'm guessing you're a South Park fan. Says, what's the issue with traveling outside the country if there is valid visa stamping? I mean, yeah, earlier this year, we were still not recommending going for stamping for sure, but we were telling people if you do have a valid visa stamp, you may be somewhat safer, still not recommended. Now, even if you have a visa stamp, it's not recommended because number one, there can be a travel ban anytime while you're outside the US. We've seen it again and again. The Trump administration does these knee-jerk reactions to things that happen in the news and no advance warning. And if you happen to be one of the people outside the US when it happens, you can't come back while there's a travel ban in place. And number two, what if they revoke your valid visa while you're outside the US? That's exactly what's happened to tons of people that are dealing with this right now with these Prudential revocations. They don't give you any advance warning. There's no process. It's not like you get an RFE with a chance to prove that you're authorized for the visa or anything like that. A visa is a privilege, not a right, according to Marco Rubio in the State Department, and they can be revoked at any time for any reason or no reason at all. So you don't want to put yourself in that type of situation where you're outside the US and end up getting a visa revoked and there's no appointments available to get a new visa to come back.
Emily, I think so. I know the answer, but I want you to back me up or probably contradict me. This gentleman is if somebody travels on advance parole, they have a valid H-1B, they don't need to go for visa stamping, you know that. And once they come back, they can file the H-1B extension, H-1B transfer, H-1B amendment. Is the $100,000 applicable for him? My answer is no, it's not applicable for him. Correct me if I'm wrong.
No, I agree with you, because when you're filing that extension, amendment, transfer, you're filing it in the US as an extension, amendment, or transfer. You're not requesting consular processing. It's the consular processing H-1Bs that are subject to the $100,000 fee.
Then comes the next question. Ramesh K is asking this question. I have an I-140 approval. I'm going to go back to India and I will stay there for 2 years and I will come back on a H-1B with a different company. Is the 100K fees applicable for me? Absolutely yes. The $100,000 is applicable when you're filing H-1B outside the country.
G. Taleja says, will the H-4 and H-4 EAD be abandoned if the H-4 leaves the country after filing an H-1, H-4, and H-4 EAD and premium processing before the decision is made? Assuming the H-4 is an extension of stay, no. If it's a change of status, yes, it does get abandoned. Change of status always gets abandoned when you leave the country while it's pending. Extension of stay does not.
H-1B stamping, can I go to closed loop of Caribbean Islands? I'm telling no. I know. I would recommend you no. If you have a ticket, I'll cancel it if I were you. Even if you have the H-1B stamping in the passport, still no.
Yeah, a lot of people on these looped cruises are getting weird updates in their online I-94, even though they never exited the country. It's showing up for some people in their travel history, for other people it's not. Some of them are getting the date of admission changing and the expiration date not changing. Some of them are getting the expiration date shortened, even though they didn't go through any kind of immigration process. So definitely a problem with that right now.
Survey ADV asks this question. Isn't that 100K rule only applicable until September of 2000 and September 30th of 2026? And it's not applicable after October 1st of 2026. That's the question he asked. Well, definitely he is very knowledgeable, but here's the thing though. I don't think so. Trump intends that way, that this rule is only applicable until September 30th. He did when he signed the executive order. You're right. He signed it as September 30th. I am sure, I think so that it will be extended. The Trump administration will try to extend it beyond September 30th of 2026. That is my expectation, though. So I want my people to prepare that it's going to be extended. I don't want people to prepare as if that it's not going to be extended.
R. Bannock says, will there be another government shutdown impacting people? That is a possibility. We have a couple more days of negotiations on that. The latest discussions seem to suggest that they're going to move forward with the budget for everything except for DHS and go back to the negotiating table for that. If that's what happens, then I think there won't be much impact, because DOL is the impact that we have the biggest problem with, not DHS. When DOL shuts down because of budget issues, we can't get LCAs, we can't get PERMs, and we can't get prevailing wages. And that slows everything down for H-1Bs, H-1B1, E3, and obviously PERM and I-140. But if DOL gets its funding and it's DHS that doesn't, everything else that we file is fee-based. And so USCIS should still be processing cases as normal based on the fee that people pay as part of that process. So we'll have to see what ultimately comes out with this budget later this week.
Our Karthik 34 has this question, and a lot of people have this question about travel. I will address all those things. Yeah, Divesh is asking that you're telling not to travel, not to travel. Where is it safe to travel? Within United States, we don't have any problem for you to travel. And that creates an interesting question for our Karthik is asked question. Can I go to Puerto Rico with expired H-1B? When he says expired H-1B, he meant to say he has a H-1B expired, but it's been stamping expired, but he has an H-1B extension. That's what I'm assuming. Puerto Rico, you can travel. Puerto Rico is part of United States. Now, one guy went to Costa Rica and got stuck, and you told me I can travel to Rico. That was Puerto Rico, not Costa Rica. Those are two different things, guys. Puerto Rico is part of United States. Costa Rica is not. Question: Alaska is part of United States. Hawaii is part of United States. Now, at the same time, I don't want the flight to go to somewhere else and then travel to Puerto Rico. For example, if some flight is going from, let's say, from Houston to Miami and Miami to Puerto Rico, that's perfectly all right. What if the flight is going to Miami to Mexico City and from Mexico City to Puerto Rico? The answer is no, do not travel in that. Same thing with Alaska. If you're traveling to Canada and from there it's going to Alaska, absolutely no. If it's directly to Alaska or directly to Hawaii and coming back, absolutely not a problem. People are asking questions with regards to the green card holders, no arrest, no unlawful presence, and never traveled outside the country for more than 180 days. That's another rule too, that you never been outside the country after you got the green card for 180 days. Are we noticing any problem for them? No, we are not noticing any problem. Another gentleman is asking, I'm a green card holder. I plan to travel. If there is a country ban, will I be able to come back? For the country bans, the green card is not in there, that you can still travel. If you have, for the 75 countries, those people who have a green card, they can still travel and come back. Absolutely not a problem.
Wealth City Villa says, my visa expires in December 2026. Do you recommend that I file my H-1 extension in premium in June, even though I have a green card EAD, but I'm awaiting my date to become current? So number one, if your company's willing to file the H-1B extension and it's a strong case, it's a good idea. It gives you a backup plan. If it's a weak case to where there's a chance the H-1B might be denied, maybe not. Maybe rely on the EAD. It also depends on the strength of your pending 485. Is your I-140 already approved? Any immigration issues in the past? Any criminal issues in the past? Is there any reason that could cause the green card to be denied, such that you need to have an H-1B as a backup plan in case that happens? So it can be a good idea to continue to have both, particularly if your company is willing.
The doctor gentleman with the EB1 is asking, can I request for my wife is stuck with a US citizen 2-year-old child? Can I ask for emergency H4 visa? You can ask. Here is a problem though. Everybody who's stuck in India right now are requesting emergency. Most of them have kids who are US citizens. Most of them, one of the spouse is stuck here in the United States. They are not honoring the emergency request. And if they do honor the emergency request and they say, okay, we are going to grant you the emergency appointment, but then they're saying we don't have any emergency appointment. So that is how the situation is. You can try. You should try. You can contact the local congressman. You can keep on trying. It may work out, but I would say that at this point of time, it's only 1% of the people I don't know about that may be working out about the emergency appointment. Yeah, for most of the people, it's not working out.
C from Facebook says, my EAD was approved a month ago in the first week of December, card not yet produced. USCIS asked me to wait for 30 days. After that, no update. What could be the reason? I don't have an answer on what the reason is, but this is a trend. I've specifically reached out to USCIS regarding this. Stephen Brown in our office has also been reaching out to his contacts regarding the potential need for litigation if they are not going to be timely processing green cards. not gotten any response as to why this is happening. No announcement. Like in the past, when it happened, USCIS at least was forthcoming, saying there was a problem with a printer or whatever the reason was. And of course, back then we had the automatic EAD extension, so it wasn't as big of a problem. But now that they eliminated that, they need to be producing these cards in a timely manner. And they're not doing that. So we are looking into litigation if necessary, because we are experiencing this for our clients as well.
Have an I-140 approved last month and companies winding down. Can you still transfer my H-1B within USA? Yes, you can absolutely. I hope the company does not withdraw your I-140 for at least 6 months after it's been approved. Then you absolutely don't have any problem. Yeah, you are an H-1B right now. You have an I-140 approval. Can you transfer to a different company because your company is winding up? You can.
A lot of people have asked how far the EB2 or EB3 dates might move forward if we have the spillover in October. It's a little soon to try to predict that. I haven't had a chance to look into the most recent inventory of the 485 data or the numbers of I-140 approvals that are out there. I don't think they're super up to date, but I haven't looked recently. So I am working on that. Hopefully soon I will give you my best guess, which will be wrong, but at least it's a guess.
Tejas is asking the question, what would be the options once the criminal case gets dismissed? How to reinstate the visa? Well, there is no reinstatement here. It has to be done by the Department of State. So for that, you will have to go outside the country to get the stamping. We tell you not to do that right now. Now, here's the thing, Tejas, for the people who have a recent any arrest records, they have their visa revoked. We understand that. It's been historically that has been the case. Let's say somebody has a DUI, if they have a visa, the visa gets revoked. However, what we noticed is that somebody has a DUI in 2012. And after that, they went back to India a couple of times, got the stampings. They disclosed every information, gave all the things. First time when they went there after they have a DUI, they got the medical examination, got the visa stamping, and came back. Now their visa got revoked. So if somebody of that, we don't know for the people who got the visa revoked, if they go back, they're going to ever get the visa because this is only implemented from December 8th of 2025. So we don't have much data to say that these people are going to get that. For those people who have visited for the visa stamping, they got the 221G as of now. None of them got the visa. So we are still waiting if ever these people, when they go back to their home country, they will ever get the visa.
Special K from X says, are you seeing more RFEs for H-1B extensions? Yes, they are increasing, both for extensions as well as transfers. What is different is they tend to be looking backwards at the previous H-1B much more closely to verify that status was actually maintained during the previous employment. So they're looking at what was the work location on your last H-1B LCA? Were you actually in that location? Do your pay stubs match that? Do they have information that you've gotten a driver's license in a different state, to where you're not actually working that location? They look at that LCA and say, this was the salary that was supposed to be paid according to your last H-1B. Looking at your pay statements, were you paid that correct amount? If you were paid less, they might say that you failed to maintain your status and they could deny your H1 extension. Then you have to leave the US and then you're stuck with a $100,000 fee to get back. So we are definitely seeing more scrutiny of the previous status before they will approve the status going forward.
Um, People are asking questions with regards to are they using the artificial intelligence in adjudicating the applications? In some cases, when we see that, yes, they are. In some cases, we don't notice that they probably are not looking into the details, though. Um, but we have been told that the USCIS has a contract with Palantir Software, which is an artificial intelligence software that caters to the governments. So the USCIS has already paid the money, so they must be using that software to adjudicate the applications.
Hemant says, are L1A visa appointments not available in the Indian consulates? I'm outside the country on an assignment for my employer. I have not noticed a delay in my clients getting appointments for L1As or L1Bs in India. So not this, definitely not the same as H1s and H4s.
Satish has this question. He filed 485 application. He's working for his own company. Is it a good idea for his wife to sign the I-485J supplement? As self-employment is allowed once you file the 485, once you cross 180 days. You're right, self-employment is allowed. However, I would rather want your application to be scrutinized well by an immigration lawyer before your wife can sign the I-485J supplement. Technically, can they do it? Yes. If there is any interview, though, we definitely recommend you take a lawyer with you so that the lawyer can explain the law to the officer that self-employment is allowed in the law and should be able to, maybe we didn't have any problem in getting the approvals, but definitely it's better to be more cautious under the current circumstances we are in right now.
Engineer 5 says, is EB3 downgrade to apply for a 485 still recommended? Yeah, no issues with that at all. It's a valid process. So if EB3 is ahead for you, you can absolutely file a downgrade using the same labor certification. With that downgrade, you do need to ensure that the company has the ability to pay the salary listed on that labor certification going from your old priority date all the way up until you're filing this I-140 petition now. So they're going to re-adjudicate the entire I-140 process. So that is one thing definitely to look at to ensure that it's a strong case, but assuming it's a decent I-140 petition, it's a great way to file the 485 earlier.
She had 3 H4 approvals and multiple visa interviews traveled since the incident. Does she still need to disclose the information in the H4 extension? This person is speaking about any criminal history. In the I-539 application, though, they're only asking the information from your last entry. Have you had any arrest or any criminal charges? They're not asking anything before, so definitely I would say no to that. However, we are noticing that anybody who is applying for the H-1B, H-4 extension, or I-140 application, if there is any arrest record for them, they are requesting them to come to the biometrics. Sometimes they're issuing an RFE not only for biometrics, they're also issuing notifications with regards to submitting the documents, submitting the documents for the arrest record. Why all those details of the arrest record?
US from X says, are L1s getting denied in India as well? I'm definitely seeing an increase in L1B rejections under blanket approvals. They're really wanting to see a long track record of time with the company. It's not enough just to have worked for the company for 1 year in the last 3 years. And then they really want to see that specialized knowledge is tied to the specific company. It doesn't necessarily have to be proprietary, according to the regulations, but that's kind of what they're looking for, is they really want to see why is this knowledge different from what knowledge is generally out there for the same type of job.
Abhishek Chaudhary is asking the question for the wage determination, wage level, does the bonus component count? No, it does not count. Only the regular wage will count. So the wage, whatever wage the company says, has to be given. So if it's been divided into 26 paychecks, then the wage has to be divided into 26 equally. Every month they has to pay. So bonus doesn't come every month; it comes every quarterly, half yearly, or yearly. So it does not count towards the wage level.
Rohit says, I sent my H4 and H4 EAD applications to the USCIS in Arizona 2 weeks ago. Not received any response. No filing amount was debited from the bank. How long do I wait and what are the next steps? So I would first ask, when is your current H4 or status expiring? If it is expiring in the near future, you may want to just refile now. Because it's very likely that something went wrong, especially with these G1650 and 1450 forms. We're getting a rejection every day, and they don't give you any reason for the rejection. They just have a laundry list of things that it could be, all related to the G1650. We turn around and resubmit the exact same G1650, and then it goes through fine the next day. So there's no rhyme or reason to it. If you do have time to wait, if your status is not expiring, you really have to wait 30 days before you can even follow up with USCIS. The best way to follow up, at least first, is to try to call them. Because if you have to email Lockbox support, they will take 60 days to respond. Now you've wasted 3 months waiting for this thing, and so it's pointless to wait. It's a big mess right now. So you may need to just refile it and deal with that rejected application later.
Um, are you seeing any current issues with regards to concurrent H-1B filing these days? This question is coming from Sairja. The answer is no, we're not seeing any issues. They are just going through normal processing right now. Nothing different than what it was before.
Senker says, can an employee authorize the 3 fees for I-140 filing, asylum program fee, premium processing fee, using the G1450 or 1650? Yes, there's no restriction on an employee paying the costs of an I-140 petition. There is a restriction on the H-1B as well as labor certification costs, but I-140 and 485, the employee can pay for.
Okay. Are you seeing any H-1B extensions getting denied? We're not noticing much H-1B extension denials, especially in the Trump 1 period. We have seen a lot of H-1B extensions getting denied. Nowadays, I would say that it has gone up a little bit, but I would say maybe by 2 to 5%, not more than that. Previously, in the Trump administration, we have seen H-1B extension denials going up by much percentage, though. So not much. But however, we strongly recommend everybody to get the results of the H-1B extension before your current I-94 expires. So let's say if your current I-94 is expiring in April of 2026, get the result before that, because just in case of any chance that the denial comes in, you will get another opportunity to file an extension.
Sai Krishna says, one of the FANG companies is going to do mass layoffs tomorrow. Does my 60-day grace period start on the day of that notice or after the severance pay is over? We would recommend in the current environment to go by the last day you went into work. So if that is tomorrow, start your grace period from that date. But if they're giving you the notice in advance, still going to be working for the next 3 months and then start your severance, then it's whenever you actually stop coming into work.
We are not noticing any problems with the I-130 green card appointments in US consulates in India at this point of time. This question is coming from Praveen from X.
Karthik says, is the 221G the new normal while going for H-1B stamping due to social media screening? And how long do you think there would be a protest guidelines on social media screening? I haven't seen anybody get into trouble with stamping for the social media screening. I mean, when they first announced it, a few people got a 221G saying that they were completing that process, but then the next day they got their visas. So I don't think most 221Gs are related to these social media screenings based on my cases and knowledge.
1 second.
Divesh says, we keep hearing don't travel. When is it safe to travel? Hopefully when we have a new president that is not worse than Trump on immigration. That would be 2020, 2030. I'm doing my
1 year
math
is
right.
1 year is over, Emily.
We got 3 more years to go.
Left, and it is very hard. We sustained 1 year. We still need to sustain 3 more years.
Yeah.
Do you see any issues with the premium processing for the H-1B extension and transfer? This is from Chakravarti from YouTube. The answer is no. We're not noticing any problem for the H-1B extensions or transfer premium processing right now.
IT Guy 007 says, how do I switch from H1 to GCEAD within the USA? Yeah, there's nothing for you to do. You can just say, tomorrow I'm going to start using my GCEAD, and that's it. There's nothing to file. There's no one to notify. The next time you're asked to fill out an I-9 for a company, if you change jobs, you just show them your EAD instead of doing an H-1B transfer. That's about it. Next time your current company asks you to re-verify in your I-9 when your H-1 is supposed to be expiring, you can show them your EAD and tell them you don't need an H-1 anymore. But there's nothing to do. It just happens in the air, in the clouds.
Can my spouse, who is a dependent on the adjustment of status, travel to India for 3 months in advance parole? The primary will remain in USA. I don't see any problem in that. I would have a problem if the primary would have been traveling for 3 months, though. But if the dependent is traveling in advance parole, I don't have a problem.
Anil says, do you think any new PERM strict rules are coming up? I don't think there are any plans to do new regulations for the PERM process. It's possible that we might see stricter scrutiny or more audits, which now all of a sudden they call RFIs. They don't call them audits anymore. So that's certainly possible, but I'm not seeing any changes in the regulations coming up, at least not within the next year.
I'm going through questions that are most. Does visa appointments for O1 also an issue in India? No, right now it's only H1B and H4 is where we are seeing a problem. O1s, we don't see that as a problem at this point of time. But we are recommending that if you're already in USA, though, don't go for stamping irrespective of whatever visas that you're planning to go.
So Rob says, are you guys seeing any issues with H-1B transfers? Nothing like we saw during the previous Trump administration, where every case was a question about the proper wage level. Was it a specialty occupation? Is there an employer-employee relationship? All of those things were happening. We have not seen that yet. I think the biggest change I have noticed are they're really looking backwards at your previous H-1B with the other employer to verify that you maintain status with them before they'll approve the transfer, which they've not really looked into that before as much based on my experience. Beyond that, it's still the typical specialty occupation, beneficiary qualifications. If you had any law enforcement interaction, we're still seeing those biometrics RFEs, and then asking to submit the arrest records and sometimes the positive discretionary factors, but we're still seeing approvals after all of that.
Mr. Babu from YouTube asked this question. I-140 has been denied because due to the inability to pay the salary. Does resubmitting the application with the tax returns and documents will help? Definitely yes. I would definitely will hire the best lawyer that's available in the entire United States on the I-140 ability to pay. And it's not Rahul Reddy and it's not Emily Neumann. It is Ryan Vick. He is very good. You can make an appointment with him. He will go through the things. He does that very often, and he's the best available in USA. So please contact Ryan Vick if there's an ability to pay. He's the master of the ability to pay. He knows. There are ways like if the labor certification has been filed on July 1st, though. He will say that the prevailing wage the company needs to pay is only from July 1st to December 31st, which is only half of the prevailing wage. He's very good in calculating a lot of things. So definitely I would recommend contacting, Ryan Wick in that thing.
Ganesh says, what's the typical processing time for EB2 to EB3 interfiling via an I-485J? It's been 3 months since I sent a request. 3 months is common. It can be anywhere from 1 month to 6, 7, 8 months. It just really depends on what officer you get, where your case is at. There's no rhyme or reason to it.
My wife is an H4 EAD. She already has an I-140 approval as well. Do you see any problem in converting H4 to H1B, cap exempt? I don't see any problem in her moving from cap H4 to H1B. I don't see any problem in her moving to cap subject H1B, but she has to go, if she does not already have a H1B, she has to go through the lottery. That's the only thing that she has to do. But yeah, once you're in United States, you're moving from H4 to H1B, that $100,000 is not applicable. Anything
Yeah,
else,
well, I
Emily?
think we are out of time for today. Thanks everyone for joining us. We'll be back again next week at 5 o'clock Central Time. In the meantime, you can set up a consultation with us or any of our attorneys by going to rnlawgroup.com. You can click on consultation. You can see all of our schedules and book it online easily per your convenience.
Thank you very much for tuning in.